Final matter to come before us today is State of Ohio versus Kimberly Greathouse. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, do let me know when you get started. I'm keeping the clock this morning and I can keep you apprised of the passage of time. We've read the briefs and we're ready to see when you are.
Thank you, Your Honors. May it please the Court, opposing counsel, my name is Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the State of Ohio in this matter. I'd like, with the Court's permission, to reserve 4 minutes for that. Thank you very much. This appeal concerns the trial court's finding of Ms. Greathouse eligible for intervention in lieu of conviction under 2951.041. And specifically, this appeal involves the eligibility criteria under Section B of that statute, specifically Section B1, which provides that if an offender has previously pleaded guilty to or been convicted of a felony offense which is not an offense of violence, for the offender to be eligible for intervention, the prosecuting attorney must recommend to the trial court that the offender be found eligible. In this case, Ms. Greathouse has a prior Summit County, I believe, conviction, which she entered into an intervention in lieu of conviction program in Summit County prior to the trial court finding her eligible in this case. The prosecuting attorney in this case withheld its recommendation that Ms. Greathouse be found eligible and specifically objected to the trial court finding her eligible. We contend that this precluded the trial court from finding Ms. Greathouse eligible because she does not meet the statutory criteria under 2951.041B1. And we make essentially 3 arguments for the court to consider as to why the trial court erred in finding Ms. Greathouse eligible. Before we get to that, I'd like to note that because this appeal concerns a statutory matter in terms of construction of eligibility criteria, we believe that the standard of review here is de novo review because it involves interpretation of the statute. Secondly, there are 3 primary reasons why the trial court erred. The first is a statutory reading of the language of the statute. Specifically, the phrase convicted of or pleaded guilty to. We believe that the or in this statutory language is disjunctive, either or. That they have equal effect and the same footing. And this language is confirmed both by the Supreme Court, State v. Gwen, 134, Ohio State 3rd, 284 in 2012, which was a review of this court's decision. Now, Gwen reversed, but on the issue of the manner of proof, not on the language question. This court was right in State v. McCumbers that the phrase convicted of or pleaded guilty to has disjunctive meaning, either a prior plea of guilty or a determination of guilt, either following a trial or sentencing, as the Rule 32 issue was commonly understood. Specifically, this same phrase, convicted of or pleaded guilty to, is used in several other criminal statutes as a statutory enhancement for sentencing purposes. And these are all cited in the state's brief. It's the same phrase as the domestic violence statute in 2919-25. It's the same phrase as the OVI statute for enhancement of sentencing offenses under 4511-19G, and for the OVI specification in 2941-1413. Specifically, in State v. Gwen, both the majority opinion and the dissenting opinion, I believe Justice O'Donnell dissenting with a judge joining, endorsed the specific language of convicted of or pleading guilty to having equal footing, equal effect, and the quote-unquote same footing, that a prior plea of guilty has the same effect as a conviction and sentence in any other case. And this language dates back to a 1994 case, State Ex Rel. Watkins v. Fiorenzo, case cited in the state's brief, 71 Ohio State 3rd, 259. So we see that the phrase that the intervention in lieu of conviction statute uses, the convicted of or pleaded guilty to language, has the same effect. So the prior plea of guilty in the Summit County case where Ms. Greathouse was placed on intervention in lieu of conviction constitutes a conviction or pleaded guilty to bar her eligibility for a subsequent offense for subsequent placement in intervention in lieu of conviction unless the prosecuting attorney recommends that she be found eligible. Which leads us to the second point. The second point here is the recommendation of the prosecutor. Now, beyond the statutory language in terms of requiring the prosecutor to make that recommendation, which in this case, not only did we not make that recommendation, we specifically objected to the trial court finding Ms. Greathouse eligible. We believe that by rendering a decision finding Ms. Greathouse eligible despite the lack of recommendation and the objection to her being found eligible, that the trial court in effect removed the prosecutor from this proceeding and withheld the prosecutor's ability to deny and essentially reading out words of the statute. The language of the statute requires, in cases where the defendant has previously pled guilty to or been convicted of felony offenses which are not an offense of violence. If they're an offense of violence, they're just not eligible. If they do have a prior plea of guilty or conviction for a non-offense of violence felony, the prosecuting attorney's recommendation is necessary. By removing that bar for eligibility purposes, the trial court essentially removed the prosecutor from the case, which constitutes a separation of powers problem, as this court considered in State v. Dopart, the Lorain County diversion program by the Court of Common Pleas. The judicial branch must respect the boundaries set on its powers, including the executive branch's authority to prosecute criminal offenses. Here, the intervention in lieu of conviction statute specifically creates a role for the prosecuting attorney to prevent eligibility in certain instances where the prosecutor believes that it's not appropriate. Here, the prosecutor exercised that discretion and withheld and objected to Ms. Greathouse's eligibility. That should have been the end of the matter.
Was the separation of powers issue raised before the trial court?
In those specific words, I don't believe so, Your Honor. I think our argument to the trial court, both on brief and at the hearings, as the record will bear out, was specifically about the statutory language and the B1 eligibility question. I think if I may, the separation of powers problem is an extension, the effect of that problem.
So you're not asking us to rule on that on a constitutional basis, I take it?
No, I think that we're offering it more as an illustrative example of why the court erred in adopting this framework for evaluating the statute, that this is the problem that such an approach would lead to. It's not an individual basis of the violation, it's kind of extrapolation. If you adopt the trial court's reasoning, these are the problems that would be created as a result. The third reason why the trial court's determination of eligibility is in error in this case is its course of conduct analysis. The trial court really hangs its hat in this case on its finding that Ms. Greathouse's conduct in this Medina County case was part of the same course of conduct as her conduct in the Summit County case, for which she previously had pleaded guilty and been placed in the intervention in lieu of conviction program. There are a number of different analyses that the state's brief conducts as to why that analysis is really not appropriate. But at its heart, the trial court relied on a second district case, State v. Drager, and it's cited in the state's brief. It's the second district. It's 2006 Ohio 2329, and the trial court identifies a conflict even within the second district as to when intervention is appropriate in this course of conduct analysis. And it identifies the conflict case as State v. Leiston, L-E-I-S-T-E-N, a second district case, also from 2006, ironically enough, 2006 Ohio 2362. Now, the trial court says, I really can't identify a discrepancy or a basis for the different determinations. Drager, the court said, intervention in lieu appropriate, Leiston not eligible, and the court said the only basis for the determination why one was eligible and one was not appears to be to the trial court. The decision in Drager says that it was part of a course of conduct. The offenses in one county were committed as part of a course of conduct for the offense in the second district county. And so the trial court found that, well, that must be a relevant determination for my analysis. The difference is, and the state argued this to the trial court, the state in Drager, the second district case, had conceded, and maybe had even stipulated, but had conceded that the defendant in that case, that Drager, was eligible for participation, which was the entire point of the appeal. The state in Leiston, later that same year, in fact not much later, 2329 versus 2362 for the Ohio website numbers, did not make such a concession, and the trial court was correct to deny eligibility. So the point of departure between those two second district cases appears to be that the state in one had conceded eligibility while had denied in the other. So the course of conduct analysis the trial court employs in this particular case as the kind of sine qua non of when a person is eligible as a continuing course of conduct. If they're eligible for one case and it's part of a continuing course of conduct, they should get it in all cases as part of that conduct, which we disagree with. That's part of the trial court's analysis in this case. However, even on that basis, the trial court's analysis doesn't really hold. These offenses wouldn't be allied offenses under 2941.25 because they're separately committed, they involve separate victims, they occur in different jurisdictions at different times. They're not allied offenses of similar import. They're 4 months apart, April 2014 to August 2014. They also wouldn't be capable of being aggregated because both involve theft of credit cards. They wouldn't be capable of being aggregated under 2913.61c under State versus Phillips, the 12th district case, which is regularly cited across the state. They're different victims. They're not committed in the same employment capacity. They're not committed in the same relationship to the offenders. They just happen to be the same offense. And they also wouldn't be properly venued in the same county under 2901.12h. They don't involve a pattern of the same conduct. It just happens to be the same offense committed 4 months apart against different victims. There's no commonality.
And counsel, you're just now reaching a rebuttal time of 4 minutes.
Thank you, Your Honor. I'll reserve the balance of my time. Thank you.
Hey, please, I'm in court. My name is Thomas Ryan. I represent the defendant, colleague. Counsel, Your Honors, good morning. Good afternoon. Trial court in this particular matter undertook a very specific and thorough analysis when it found my client to be drug dependent and deemed her eligible for intervention in lieu of conviction. Trial court issued a journal entry, and I submit, although the trial court may have undertaken a de novo review, the only cases I could find out of the second district and the only cases cited in my brief or the prosecutor's brief had to do with an abuse of discretion. And obviously, for this court, I submit to overturn the trial court's finding, you would have to find that the trial court abused its discretion in allowing Ms. Greathouse to participate in the intervention in lieu of conviction program.
Well, how do you address the state's argument that the proper standard is de novo because we're not really looking at the factors that the court considered so much as we are the language in the statute?
Well, I think the court is looking at the factors. I think this court has to look at the factors because the trial court specifically made a finding that this was a course of conduct. Now, again, the prosecutor's throwing some different terms out there, talking about venue, which we know if one action or one part or element of a crime occurs in one jurisdiction and another element occurs in another jurisdiction, venue in both places are proper. Okay. I'm not making the argument that these are allied offenses of similar import. The only thing I'm sitting there that I can liken this to is that this is a course of conduct which the trial court made that specific and distinct finding because Ms. Greathouse in both these actions, both these incidents, took credit cards.
Were the credit cards taken at the same time?
No.
So they're taken at two different times from
Absolutely.
2 different victims.
Correct.
So
Correct. But here, the only thing
4 months in between the two events.
But the only thing I can think of is you have a similar type of crime under the Ohio statute where engaging in a pattern of corrupt activity. And that's normally has this sort of course of conduct type analysis.
But she wasn't charged with that.
Was not charged with that.
Or
But
with drug abuse, which really would have been,
Right.
that would have been the course of conduct is continuing drug abuse? Is
But
that-
the only thing I can make an analogous to is a course of conduct type thing in a pattern of corrupt activity in a RICO type manner. Something that's ongoing over a period of time. And the trial court listened to arguments from both the state of Ohio and defense counsel. The trial court undertook its analysis. The trial court reviewed the cases that were in front of it, and those are only cases from the second district. And the court found that this was, in fact, a course of conduct. Now, it's not like these incidents happen years apart, and certainly they're not all offensive similar, but I'm certainly not making that argument. But what I am arguing to this court is that the dates of offenses, one was April 2014, Summit County, one was August 2014, Medina County, both within the 9th District, and I've never had the pleasure of arguing here before. I had 2 oral arguments in the 8th District yesterday, one this morning, so I've never had the pleasure here. It was in the 11th District not too long ago, been there high Supreme Court at least a dozen times. So what I'm saying is both Summit County, both Medina County fall within the 5th District. Not that that necessarily matters, but my point is the trial court undertook the analysis, made a heartfelt decision, issued its opinion after it made the specific finding these occurred with the same course of conduct. And I submit the only way that this honorable court can reverse the trial court's finding is to make a finding that basically the trial court abused its discretion, meaning that it was unreasonable, arbitrary, and unconscionable. But I don't think if the court looks at the underlying purposes here, again, these are not offensive violence, not to minimize her actions here, but these are offenses that her drug addiction basically was a factor in making the decisions that she made.
But she wasn't charged with that, though.
What's that?
She wasn't charged with that.
No, but that's intervention in lieu of conviction. That's intervention in lieu of conviction, that there's certain factors, unless they're offenses of violence, that make her, she's eligible for intervention in lieu of conviction. Judge Pfeiffer in their high Supreme Court basically is talking about treating the cause instead of the incident or crime itself. And that's what we have here. Now this young lady is undergoing drug treatment, she's having urine screens, she's having classes whereby she's attempting to deal with her drug addiction.
But even your brief states that, if you're directly quoting from Justice Pfeiffer's column, it does say it's an opportunity for first-time offenders. That's what you wrote that in your own brief. It's
absolutely.
First-time offenders to receive help for their
absolutely.
offense.
But here, and I'm going to go specifically to the journal entry that was, I think, an exhibit that the state of Ohio put in. I certainly know as part of the record for the Summit County journal entry, which held basically, upon due consideration, the court holds a finding of guilty in abeyance. So I know the prosecutor's talking about some semantics, some rhetoric, talking about pleaded guilty or been convicted of, but here, that Summit County case specifically, the Summit County Common Pleas judge specifically held that that finding of guilty would be held in abeyance. And I submit that Judge Kimberly...
We're talking about the finding. Did she plead guilty?
Well, and here's what it says too. The defendant, the journal entry, obviously the court speaks through its journal. We know that now, if not more than ever, especially since the Ohio Supreme Court ruled upon now that everything's got to be in the journal entry itself. And here's what the court said in this journal entry. Court retracts her plea of not guilty heretofore entered and for plea to the indictment says she is guilty of. Now, I don't want to get hung up on the semantics because she has to obviously plead guilty to be eligible for intervention in lieu of conviction.
Right.
My point is that the trial court, in this case, did not abuse discretion because it found that it was specifically a course of conduct.
But we don't get to that if we, or at least we may not get to that, if we begin by looking at this issue of whether or not the trial court could even make the finding where the prosecutor did not make the recommendation. So you're kind of jumping over this language of whether she was convicted of or pleaded guilty to.
So if you want me to address specifically the prosecutor having to make the recommendation, well, there's a lot of times where prosecutors don't make recommendations. Another example I can think of is in eligibility for judicial release, if the prosecutors find that no, we object to judicial release at this particular point for this reason, this reason, this reason, this reason, then it's up to you folks basically to make a decision whether it's proper or not. And I submit this is the same type of analysis that needs to be undertaken here, that again the trial court did not abuse its discretion by making this particular finding to allow her into the intervention in lieu of conviction. And again, we all know the direct and collateral consequences of a felony conviction. I don't think I need to go into those: loss of jeopardy, loss of freedom, loss of ability to earn income, loss of ability sometimes to even get jobs or serve in the military, or 100 other things. So this is an opportunity for her to avoid a felony conviction, to move on for her life, albeit because of her own drug admitted addiction.
So was she doing ILC in Summit County?
Yes,
She was already doing it there.
yes.
So why,
Yes, he already began intervention with conviction. Yes,
At the
that-
time she picked up the charges.
That's my understanding. Yeah, that's my understanding. And I don't think that's in dispute. I don't think they indicate, no, not either way, or say, no, it was held in abeyance. The only thing that was held in abeyance was the finding of guilty,
Right.
according to the journal entry.
Because you got to complete the program.
Right.
Then you get the,
Right. But again, I don't think it's my opinion, for what it's worth, that the trial court here undertook an analysis that was unreasonable, arbitrary, or unconscionable. The trial court looked at the cases from the second district, talked about the course of conduct, just didn't do it on a whim, so to speak. It was just not something that was out there. It was a well-reasoned decision, and the court issued its findings, factors, and the rulings. In essence, honorable court to affirm the trial court's ruling and to overrule the state's argument and position here. If your honors have no further questions, I think the court understands my arguments and position.
thank you.
Thank you, Your Honor.
May it please the court, I'll attempt to be brief. The issue, at least in terms of the convicted of or pleaded guilty to language, the 2951-041B1 uses this particular phrase, and the statute reads, and it's cited at page 5 of the state's brief. The offender previously has not been convicted of or pleaded guilty to a felony offense of violence, or previously has been convicted of or pleaded guilty to any felony that is not an offense of violence, and the prosecuting attorney recommends that the offender be found eligible for participation in intervention in lieu of treatment under this section. And it goes on and has some additional explanations not really relevant in this case. The argument that the appellee asserts here is that, well, there's other statutes where the recommendation of the prosecutor doesn't matter, and he cites the judicial release statute. This statute, 2951-041, specifically requires the recommendation of the prosecuting attorney. I don't believe that the judicial release statute has any such recommendation. In fact, the offender is eligible if they're not serving a mandatory prison sentence under 2929-13, and they show good cause why they should be released early. The prosecutor can object, but their failure to object doesn't necessarily mean that the offender is automatically granted release. Here, the statute works quite the opposite way. The person is for sure not eligible if they have a prior offense of violence. That's the first subpart of B1. And then it says, or previously has been convicted of or pleaded guilty to any felony that is not an offense of violence, and the prosecuting attorney recommends the offender be found eligible. It would be an absurd reading of the statute, I believe, for the court to say that the or in convicted of or pleaded guilty to is disjunctive, and the conjunctive and the prosecuting attorney didn't also have any effect. If you read out the ability of the prosecuting attorney to recommend or withhold that recommendation for the trial court to find an offender eligible, you have done violence to the wording of the statute and read words out. And that violates your duty of statutory interpretation under Foley versus Goodyear Tire and Rubber. The other thing I would note is that clearly under the intervention in lieu of conviction statute, a person has to tender a plea which must comply with Rule 11. As a Rule 11 compliant plea, the person has previously pleaded guilty to an offense. The fact that the intervention in lieu of conviction statute says that in Summit County, for example in this case, the trial court doesn't make a finding of guilty does not mean that the person hasn't tendered a plea, hasn't gone through that whole colloquy. And the entry that he reached you today confirms that fact. So the Rule 11 compliant plea is made. Ms. Greathouse therefore has previously pleaded guilty to an offense which is not an offense of violence. The prosecuting attorney's recommendation was required for her to be statutorily eligible as a threshold gateway issue before any of the course of conduct language could even be considered. Because you are interpreting the statute, I believe that your review is de novo review because you are applying just the words of the General Assembly as codified in the revised code. Nothing more. So if I may though, what might trip this court up as it conducts its review, and this is answered somewhat in the state's motion for leave, is whether this is a final reviewable order. And I wanted to give the court an opportunity to address any questions it might have about that. I would note that the cases we cite State versus Castro, specifically out of the 12th District in 2009, makes a determination under 2505-02B1, I believe, that the finding of eligibility in an intervention in lieu of conviction case affects not a substantial right of appellee, this is paragraph 10 of the opinion. In this case, it is not a substantial right of appellee, the defendant, but that of the state, which is affected by the trial court's decision granting appellee's request for intervention in lieu of conviction. If the state is prohibited from appealing the decision, it is without further recourse to challenge the propriety of the trial court's order. Now,
And counsel, thank you.
thank you very much, Your Honor.
For your presentation this morning. Thank you both.
Thank you.
The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website. We are adjourned until Thursday in Wayne County.